There used to be a point in time where employers had no obligations or legal responsibility towards their employees. Before the Civil Rights Act of 1964, the only law organizations had to truly abide by were wage and hour laws. When the bill for the Civil Rights Act of 1964 was passed, the way workers were treated began to see improvements, and even though these improvements were small, it was the beginning of a new era. With the expansion of labor laws came with it the expansion of the Human Resources Department and its duties. It was essential for those seeking employment in an HR department to receive the proper education to learn the ins and outs of the employment laws because these laws would impact the way they perform their job. People working in HR learned about earlier legislations such as the Social Security Act of 1935, the Fair Labor Standards Act of 1938, and the Equal Pay Act of 1963, and of course the monumental Civil Rights Act of 1964. Because those legislations were created during a different society, remaining in compliance with some of them might not require as much attention from HR. However, other laws, such as the Drug Free Workplace of 1988, Americans with Disabilities Act of 1990, and especially the Occupational Safety and Health Act of 1970, call for continuous HR involvement. The Occupational Safety and Health Act was designed to help ensure a safe place to work for people that were in the workforce, and it was meant to help prevent work-related injuries or even death from occurring in the workplace. The OSHA Act's past is a constant piece of a long battle over the entitlement to a protected and sound working environment for working individuals, and this battle can be traced all the way back to the post-Civil War era. It was during this era that America was moving away from an agricultural society to an industrial workforce. This change of life brought innovations and modifications that expanded the hazards that individuals faced while working. As a result of the new dangers these hazards presented, unions started to chase after better working conditions, an increase in pay, and a work week that wasn't quite as long. They did so by protesting at a May Day parade during 1886 in Chicago. Preceding this protest, a number of other ones began to emerge, carried out by bakers working in New York City. These bakers were not only working 18-hour days, but they were doing so under terrible working conditions. Eventually, the state passed a law in 1895 that restricted bakery workers to only 10-hour workdays, but in 1905, this law was deemed unconstitutional during the case of Lochner versus New York. It was not until a large fire broke out 6 years later, where, as stated in paragraph 4 of the article titled Triangle Shirtwaist Factory Fire, and I quote, "The public outcry over what was clearly a preventable tragedy brought a renewed sense of urgency to the labor movement. During this fire, 146 women were killed. Some were burned in the fire, and others jumped out of windows that were 7 stories high, while ongoers watched helpless. In this factory, there was only one fire escape, which was destroyed in the fire, and management kept all the other exits locked due to fear of theft. As a result, states began to create laws that enhanced factory inspection systems and kind of nudged the labor and health departments to be more attentive to health and safety in the workplace. Truly, it was not until 1936, when the Walsh-Healy Act was passed, that any national legislation existed to aid in the improvement of working conditions. This act made it mandatory for organizations that had written agreements greater than $10,000 with the federal government to follow specific standards regarding health and safety in the workplace. In 1968, President Johnson tried to create a new piece of legislation that aimed to protect the health and safety of workers, but proved unsuccessful. A year later, in 1969, President Nixon presented a new legislation with the same intent to Congress, and this legislation would later go on to become the Occupational Safety and Health Act of 1970. Along with the passing of the act, the Occupational Safety and Health Administration was created to help with carrying out workplace standards through training and education. One of HR's responsibilities includes making sure the organization, managers, and employees remain up to date with OSHA's regulations and remain compliant with all of its standards. If a company is found to be not compliant, it risks the chance of a financial penalty or even a potential lawsuit. OSHA performs inspections to make sure businesses, especially with high-risk hazards, are following standards. And if they are not, they are reported. And the business can receive a citation anywhere from $7,000 to $70,000. Since it is the employee's right to to a workplace that is free from harm and HR's role to create a positive work environment, it is HR's duty to make sure that employees are receiving the proper education and training regarding OSHA standards. HR should work to make sure that all workers continue to be free from harm or hazards and to create a culture of health and safety in the workplace. Managers in HR should remain up to date with OSHA regulations and ensure that when teaching employees about correct protocols, that the information being presented is error-free and up to date, that every employee is available and able to receive the safety education, and that overall a culture of safety is present throughout the organization. Doing so supports the employee's right to a safe workplace and shields the company's legal responsibility. When an employee is discovered to be not compliant with OSHA standards, HR should step in and take corrective measures to amend the issue. HR should meet with the employee and re-educate them on safety protocols that were not adhered to, and if necessary, HR should begin the progressive discipline process, starting with an oral warning. While reports have proven OSHA surveys do enhance working conditions over the years, OSHA's power to direct has considerably declined. As reported on the United States Department of Labor's OSHA Data and Statistics webpage, there are approximately 1,850 inspectors responsible for the health and safety of 130 million workers. That is one compliance officer for every 70,000 workers. Not to mention the time and effort it takes OSHA to keep up with the changes in the workplace. Because the OSHA Act has been seldom changed, Scenario reports that the Act requires strengthening and modernization. The OSHA Act should also seek to add that all organizations should initiate a plan of action that promotes the health and safety of its workers, and that includes recognizing and fixing threats in the workplace, regardless of if the threat is protected under OSHA or not. Until then, HR portrays a substantial part with advancing the quality of the workplace, and it's HR's duty to master OSHA regulations to ensure the safety of its workers. Because protecting a worker's right to a safe place to work is an important responsibility of HR, they should create strategies that cover risk management, training, and assisting in the development of programs to help reduce injuries. Successful strategies that promote safety should have full management and employee involvement and be clearly communicated. Employees should be encouraged to participate in safety plans, especially since they are the individuals who encounter the safety risks on the job. And workers that are actively involved with the decision-making process will almost certainly help more when it comes to reinforcing and following safety protocols. At the end of the day, HR's role involves more than just hiring and firing employees. And HR's abilities not only benefit workers, but the organization they work for as well. HR's main responsibility is to act as an advocate for employees and promote a safe and healthy workplace, and they can do so by complying with OSHA standards and implementing programs that strive for safety. Under the Occupational Safety and Health Act of 1970, employees have the right to work in a place that is free from harm. It should be the goal of not only HR, but the company as a whole to ultimately protect the right of its workers, because without those workers, the company would be nothing.